Hello everyone, this is Brian Ka with another video on Brian Ka Video to help you pass the California Baby Bar and the bar exam. So we're gonna do another real property question. This was administered in 2002 of February, and this was, I believe, the oldest test that you can find on the California bar exam. So the answer that they chose as the model answer was a little bit confusing. So from this video, I hope to clear some of that up, show you how I analyze this particular question so that you can use this video as a reference guide to basically compare and contrast how you derive that your own answer. And another thing that I think is important if you're trying to pass the bar exam like me is the fact that you want to write as many essay questions that you can. I heard from a person who is over 50 and he passed the bar exam, but he told me the best thing to do is to basically write out every single test, even the ones if you can find on outlines like Gilbert's, they have some sample questions which are usually a little bit harder. But if you do harder questions, practice with them, the questions that you'll do for the real bar exam will be pretty much pretty easy compared to the ones that you've practiced on. So let's see what this question from 2012 is saying. Let me read the question. So Donna was looking for a place to live. Perry owned a two-story home with the second story available to lease. Donna and Perry signed a 2-year lease that provided in part lessee may assign the leased premises only with the prior written consent of lessor. Upon moving in, Donna discovered that the water in her shower became very hot if Perry ran water downstairs. When Donna complained to Perry about the shower and asked him to make repairs, Perry refused, saying, I'll just make sure not to run the water when you're in the shower. Perry soon adopted a new diet featuring strong smelling cheese. Donna told Perry that the smell of the cheese annoyed and nauseated her, and Perry replied, Too bad, that's my diet now. After constantly smelling the cheese for 3 weeks, Donna decided to move out and to assign the lease to a friend who was a wealthy historian. Donna sought Perry's consent to assign the lease to her friend, but Perry refused to consent, saying, I've had bad experiences with historians, especially wealthy ones. Thereafter, every time Donna took a shower, Perry deliberately ran the water downstairs. After 2 weeks of worrying about taking a shower for fear of being scalded, and with the odor of cheese still pervasive, Donna stopped paying rent, returned the key, and moved out. At that time, there were 22 months remaining on the lease. Perry has sued Donna for breach of the lease, seeking damages for past due rent and for prospective rent through the end of the lease term. What defenses may Donna reasonably raise and how are they likely to fare? Discuss. Okay, so one interesting thing that I noticed from this past exam is that they're not asking for us to analyze Perry's stance. Usually, bar questions will ask, like, what's Perry's likely outcome? What are some defenses that he can reasonably assert? And then they'll ask, what's Donna? Does she have any, legal remedies? Can she, sue Perry under any um, causes of action? What are some defenses that Donna can reasonably raise? But this question is asking only for defenses that Donna may reasonably raise, and how are they likely to fare? So, in a way, this is easy. You're easier than trying to analyze Perry's position as well as his defenses. But in order for us to talk about or analyze Donna's defenses, most likely we're going to have to touch upon some of the causes of action that Perry may bring, and what or how Donna can reasonably use, what defenses she can reasonably use to defend against that. So, first, what I see here is that in this section, it says that Donna and Perry signed a 2-year lease that provided in part lessee may assign the leased premises only with the prior written consent of lessor. So when you see a fixed term tenancy in a lease, um, we call that tenancy for years. And this usually refers to fixed term leases such as 1 year or 2 years, right? In this case, what do we have? We have a 2-year lease signed by Donna. And there are duties of landlord and tenants, but one of the main duties of a tenant is the duty to pay rent. There's also a duty to, if there's third party tort that occurs on the property because the tenant invited that person, the tenant would also be liable for that. And there may be instances where you'll have to talk about tenant's duty to maintain and repair, unless it's stated in the contract leasing agreement that the landlord is responsible for repairing. Unless that's written in an express agreement, it is more likely, or generally speaking, the tenant has to repair, or has a duty to maintain and repair. There's some situations that are exceptions to that would be if there's a duty to repair common areas. When it comes to common areas, the duty doesn't, the tenant is not responsible to fix the common areas. That duty goes to um, the landlord. But mainly in this scenario, I think we have to talk about uh, Donna has a duty to pay rent, right? And 2 years. And what happens if Donna breaches this duty? Perry may sue or evict her. So I think that this is good to talk about briefly, just so that the that we show the bar grader that we understand what this lease is about. Um, so this is a tenancy for years lease for the duration of 2 years. Just to let the bar grader know that there are different types of tenancies, and we recognize that this was a fixed term lease, such as 1 year or 2 years. In this case, it was a 2 year lease signed by Donna. So when you have a 2 year lease signed, that means the tenant, who is Donna in this case, has a duty to pay, right? So since it's a 2 year lease, she has a duty to pay for 2 years. If this duty to pay is breached, unless there are circumstances letting her get away from that, Perry, who's the landlord, may initiate a lawsuit to try to recover that money or evict her, go through an eviction process in order to, possibly find somebody else and relet. So let's talk about duty of landlord. Maybe we should go tenant in Atlanta. So generally, tenant has a duty to maintain and repair the premises, right? Unless they signed an agreement indicating otherwise. However, landlord has a duty to repair common areas, right? Um, so basically, what I'm trying to achieve here is the fact that um, the water issue that we're seeing here, let's see. The first thing is that the water in the shower became very hot if Perry ran water downstairs. When Donna complained to Perry about the shower, asked him to make repairs, Perry refused, saying, I'll just make sure not to run the water when you're in the shower. So, what would be Donna's argument? Donna will argue that the water becoming very hot to the point where it was scalding her skin was part of a bigger problem that is not within her duty to fix, but rather part of the common area plumbing that needed repairs. To back this up, she will say that the fact that the water became so hot only when Perry ran water downstairs, prove that the water system was connected rather than being separate, right? That would be a reasonable argument that Donna could make here. Um, what would Perry say? Perry will say, well, counter by saying that the hot water issue was still part of Donna's premises and did not, and the common area did not affect the water temperature and had no direct relationship. Something like that. That's what Perry would say that since a landlord has a duty to fix common areas, he'll say that that was not part of the common area, so he doesn't have a duty to fix it, right? Since that was not part of common area, he had no duty to fix. Because the uh, because when Perry turned on water, because Terry turning on water caused Donna's water to become scalding hot, the court will recognize that the water issue was not part of just Donna's premises, but was connected to the entire system, which would be part of common area, right? Um, so, therefore, since this would be considered a common area fix, court will likely hold Perry responsible for, because Perry is the landlord responsible for fixing this problem. As a result, um, Perry or Donna may argue that Perry breached his duty and establish that she not establish his duty and use this as her use breach of duty as her defense, right? So we defined tenancy for years, kind of talked about duty of tenant and landlord. um, so I want to talk about a little bit about Donna's duty to pay, right? And I want to say that in common in common law, tenants' duty to pay and was an independent covenant. So even if the landlord did not repair, the tenant was still obligated to pay, right? Modernly, this law has been expanded, and if it affects the um, habitation of the tenant may withhold rent, um, deduct rent, and repair or leave. Right. So I talked about what would happen if there was a breach of duty by the landlord, who is Perry in this case, because we established that was a common area duty by the landlord, which was breached. So what happens if that's breached? That's what I was trying to answer here, and I said, in common law, there was an independent covenant between the landlord and the tenant, and even if there were no repairs made by the landlord, the tenant was still obligated to pay, right? But modernly, this statute has been expanded to include in situations where, if the lack of repair goes to the heart of tenant's habitability, then the tenant may have the right to withhold rent, deduct and repair, or just simply leave. So, conclusion. Therefore, Donna may argue breach of Perry's duty and either withhold rent, deduct rent, and repair or leave. Feel like that's a little bit of repetition, but that's all right, because this is not a conclusion, but I want to make sure to let them know that here's the issue, here's the rule, here's my long analysis, even though it could be better. Another one here, I talked about um, the law here. I guess I didn't have that much analysis, but I ended up concluding here that Donna may argue breach of Perry's duty and either withhold rent, deduct rent, or repair or leave. All right, so I guess that's one thing that I could do. Another thing is this here. After constantly smelling the cheese for 3 weeks, Donna decided to move out and to assign the lease to a friend who was a wealthy historian. right? And she said that the odor of cheese was still pervasive. Um, and that situation calls for what we know as nuisance, right? I talked about this in my previous video that there are some overlapping issues when it comes to real property essays. Um, one of them being trespassing or trespass. Another would be nuisance, right? So, what's nuisance? Basically, unreasonable, right? And substantial interference with person's right to enjoy land, right? And I guess we can talk about, it should affect the person of normal sensibilities. Um, but I guess we can talk about that later. But I guess if you can expand nuisance law a little bit, but as far as I remember now, uh, the main thing is whether it was unreasonable and substantial. And that's what I want to argue here, saying, Donna's argument would be, you know, someone eating so much cheese and, and letting the smell, rotting smell, permeate throughout the property is what not what a reasonable person in the position of Perry, who is the landlord, would do, right? You can make things up. Like no one goes on a cheese diet when there are close neighbors living near. This would be absolutely unreasonable. Perry would argue um, he's not using any chemicals or inherently dangerous um, objects. It's just cheese, right? And he would argue Donna seems to be extra sensitive. Um, and a person of ordinary sensibilities would not complain about cheese smell. Rather, they would enjoy it, right? I'm just, making an argument for both sides, and then it doesn't matter how you conclude it, as long as you conclude it saying the court will probably rule that cheese is not s- so unreasonable, since it is food, and to make cheese smell unreasonable would invite frivolous lawsuits in the future. Therefore, it will say that Perry did not act unreasonably. We already said that the foul smelling cheese is not unreasonable, so that ends the argument. But for the purposes of this bar exam, we have to also argue that strong smelling cheese makes Donna nauseated and is a substantial interference of her right to peaceful enjoyment of property, right? Perry, right? Again, he is not dealing with inherently dangerous substances. He really enjoys eating cheese, and a person of normal sensibilities would not consider smell of cheese to be substantial. Again, court will say that strong smelling cheese is not a substantial interference, um, and would add that Donna was seen to be extra sensitive, as opposed to persons of ordinary sensibilities. Could have probably done a better job, but basically, I talked about nuisance, and obviously, here I would write something like Donna would try to, defend herself by saying that there was nuisance at the premises, and this is one of the ways that she can try to uh, get out of the lease or not pay or leave. But, you know, we must conclude that it is very unlikely that the court will say Perry's actions constituted as a nuisance, and therefore will Donna will not be able to use nuisance as a defense in this case. And just, you know, let the bar graders know that I understand that nuisance requires unreasonable and substantial interference with persons' right to enjoy land, unreasonable interference, but I said that it wasn't unreasonable. Was it substantial interference? And I said it was not substantial. Now, if there was a nuisance here, I may write a defense to nuisance saying something like, Perry would counter that Donna came to the nuisance because that's one of the defenses you can use. But since there was no nuisance here, I don't think I want to go that far. So I think that I would just end the nuisance argument here, right? The next thing that I want to do is probably she can probably say that there was a breach of implied covenant of habitability, right? Um, so what is this? Basically, the landlord must provide uh, the premises that is fit for human habitation, such as running water, electricity, or any basic needs for human life, right? It must be habitable. What will Donna argue, right? Um, let's find some facts. Hot water to the point where her skin was scalding. That's one thing. Another thing is, after asking Perry to fix, he refused, saying he will just make sure not to run the water when she's in the shower. That's another thing. I guess you can add here strong smelling cheese. No, because that's not habitation issue. So let's move on. So I guess she would have to argue that the water is the main issue here, right? It looks like it. There was cheese, there was water here. Deliberately running the water downstairs when Donna was taking a shower. This was intentional. Um, and with malice, just add that, right? Perry, the water worked, right? If the water did not work at all, he would be violating the covenant. But since it worked fine, there shouldn't be an issue. He may also argue that him taking shower was just coincidental. He never intended to intentionally harm her, right? Taking into consideration totality of circumstances, it is likely that the court will say that Perry's actions were deliberate and the water becoming so hot to the point where Donna's skin was scalding was enough to violate implied covenant of habitability. So, what are Donna's remedies? So, Donna may do what? Um, leave, right? That's the first thing. So, second thing that she can do is repair and deduct. Third thing, withhold rent, or she can stay and sue. So obviously, this is going to be in a sentence form, but we talked about implied covenant of habitability. Um, we analyzed it from both perspectives, and then we concluded, and we also talked about Donna's remedy. So I think that's good. So far, what do we have? We have tenancy for years. We talked about breach of duty when it comes to duty of tenant and landlord. Donna's duty to pay concluded. We talked about nuisance. We talked about unreasonable interference. We talked about substantial interference. We concluded. And then we talked about implied covenant of habitability. And then we talked about Donna's remedies, what she can do since there was a violation. All right, so I think it's implied warranty. Okay, the next is implied covenant of quiet enjoyment. Okay, so the tenant has a right to enjoy the premises, right? If this is breached, she may um, leave using constructive um, eviction. And then I would talk about constructive eviction. And let's see how much time we got. It's 44 minutes, so let's try to finish this in 15 minutes. Um, without substantial interference from the landlord. So, number one, substantial interference, right? Notice and give landlord reasonable time to fix, leave. So after talking about implied covenant of quiet enjoyment, what is that? It's when the landlord substantially interferes tenants' right to quietly enjoy the premises. And if this is breached, the remedy is for the tenant to say she was constructively evicted, and in order to prove this, we have to obviously prove each element, which is obviously arguable from both sides, right? Um, I guess I wasn't using. Looks like I was using this. All right, so substantial interference. Was there substantial interference? Um, Barry deliberately ran the water downstairs. This made the water so hot that she, her Donna's skin scalded. Also, she, the cheese smell made her nauseous. After she told the landlord it was making her sick, he said, "Too bad." Also, she complained about the water temperature. He refused to, right? So I would say, was there substantial interference? I would say yes. So, yes, substantial interference. So, was there notice? Let's see if there was. When water got so hot, Donna complained to make repairs. Perry refused. When cheese smell became unbearable, she complained and was refused. So, no need to see if there was reasonable time given to the landlord to fix the issues because Perry refused them outright, right? Therefore, there was notice, right? Next, we have to say that did she leave? Here, after 2 weeks of worrying about showering and fear of being scalded and the odor of cheese, she returned the key and moved out. So there was, so Donna satisfied each element of constructive eviction. So she was constructively evicted, which means that she will not be accountable for the 22 months left on the lease. But if she owed any money prior, it is likely that she will have to pay that, right? Okay, so the next or final thing, let's see how much time we got. We got 10 minutes. Um, Abandonment. I will talk about abandonment and I'll tell you why. In case the court doesn't grant Donna constructive eviction, she would her leaving would be considered abandonment, right? If this is the case, the landlord or Perry will have um, some options available, and they are um, take possession and relet, accept surrender, right? Do nothing and sue. Um, Duty to mitigate. In many jurisdictions, if the landlord decides to repossess and relet or do nothing and sue, he or she is required to mitigate the damages by trying to find an alternate tenant as soon as possible. In this case, um, Donna, what did she do? Try to assign her lease to her a friend who was a historian. Perry said he had bad experiences with historians, especially wealthy ones. This may not be reasonable in the eyes of the court because Donna did her best to try to replace her lease with another, and Perry outrightly rejected it, right? Since the landlord has a duty to mitigate damages, and in light of the fact that Donna stepped out of her position to even find a replacement, will be considered as very breaching his duty to mitigate the damages. Therefore, it is likely that if Perry does end up getting any money for Donna's abandonment, it will be reduced by the amount that Perry accumulated as a result of failing to mitigate damages. And we have 5 minutes left. We did that in 55 minutes. And I talked about 5 minutes. Now, whether or not this is a passing essay, it may not be like a 85, but I think it's a pass. I think it's like at least a 70. There are parts where I would probably expand and like write it out instead of doing like one or two or three. I still like to use one, two, and three in my essays because for organizing essays, I think that is a good idea. But definitely, if this was a real exam, if I didn't have to talk, I would definitely expand some of these parts. But I think you get the point. And this is how I would do this question. I think duty to mitigate can definitely be expanded. It's a little bit too short. But anyhow, this was another example of how I would write a real property essay. And if you watch this video, I hope that this is a good sample for you to compare how you derived at your answer, and just a good thing to see how other people would answer this. So with that, I really thank you for watching another video of mine, and I'll see you next time.